Bonjour à toutes.
Welcome, everyone,
Je suis
and good
heureux
afternoon.
d'introduire aujourd'hui notre colloque
It is my great pleasure to
Exportation d'armes
introduce
françaises et conflit au
our
Yémen,
conference today,
responsabilité des
French
États
arms
et devoir de
exports and
vigilance des
conflict in
entreprises.
Yemen, responsibility of states
Ce colloque se
and
tient
mandatory due
en ligne,
diligence of companies.
étant donné les
This is an
circonstances, se
online
tient sous la présidence
conference,
de Monsieur le député
and
Dominique
we
Potier.
are kindly
Nous
hosted
avons l'honneur
by the
d'avoir avec
MP
nous qui
Dominique
introduira et
Potier.
conclura le colloque.
We are very pleased to
Monsieur
have
le
him with
député
us,
Dominique
and he
Potier
will
est
speak the
membre de la
introductory
Commission des
words
affaires
as
économiques à
well as
l'Assemblée
the
nationale
concluding
au
remarks.
sein du Parlement
Mr.
et
Potier
a
is a
été
member
rapporteur
of
de la
the
loi
Economic
Devoir de vigilance des sociétés
Committee
mères et des
at the
entreprises
National
donneuses d'ordre.
Assembly at the French
Ce
Parliament, and
colloque
he's
est
the rapporteur
co-organisé
of the law
par
on
Amnesty International
mandatory due
France et le
diligence.
Centre européen pour les droits constitutionnels et humains.
This conference is
Et
co-organized by the
je terminerai sur cette petite
ECCHR and
incise.
Amnesty International
Notre
France.
organisation est
Allow me
mobilisée, notamment
to
depuis
say
septembre
that
2019,
Amnesty
sur une
International
campagne qui s'intitule Silence en armes, appelant à
has
plus de
launched a
transparence et de
campaign
contrôle
called
sur les ventes d'armes
Silence
de la
en
France.
armes in
Alors,
September
quelques points techniques
2019, calling for
pour
more
tous les
transparency
participants et
and more
participantes.
control
Ce
of the
colloque est en
arms
ligne. Il se
sales of
tiendra de
France.
14
Now,
heures à
a
16
few
heures.
practical remarks.
Vous
This is an
disposez
online conference
en
from
bas de
2
votre
to 4.
écran d'une
At the bottom
icône
of your
qui
screen,
représente un
you
globe.
have a
En cliquant
globe,
sur ce
the
globe, vous
icon
pouvez
of a globe.
choisir la
Now, if
langue
you
dans laquelle
click
vous voulez suivre ce
on
colloque,
this
en
globe, you can
anglais ou
choose
en français.
which language you want to listen to.
Donc,
That could be
ce colloque se
French
tiendra
or
en traduction
English.
simultanée.
There will be simultaneous
Nous ne verrons
interpreting.
à l'écran que
What you
les
will be able to
participants,
see
les panélistes.
on screen is only the
Si
panelists.
des questions, évidemment, se présentent,
We hope
vous
that there will
avez
be questions, and
une icône
when you have a
Q et
question,
R tout en
please
bas de l'écran
click
entre
on the icon
l'icône participant et
Q&A.
l'icône converser. Vous pouvez
So that's
avoir
between
accès à une
participants.
icône Q&A,
And the
QNR
next one,
pour
you
poser des
have an
questions.
icon Q&A on which you can
S'il y a beaucoup de
click
questions, il sera
in order
procédé à
to
un
ask your
choix,
questions.
évidemment,
Now, if we have too
pour
many questions, then we
pouvoir
will
répondre
select
à
the
toutes les
ones that
questions.
seem most
Le
relevant so that we
webinaire,
can
le
answer
colloque en
as many
ligne
questions
sera
as
enregistré
possible. The
et mis à
webinar will
disposition
be
par la suite en
recorded,
ligne. Donc,
and it will
on
be
peut
available
participer pour
online
le
later
regarder à
on for
nouveau.
all those who haven't been able to take
S'il y
part
a des
today.
députés ou des sénateurs qui sont
Should
parmi
there
les
be any
participants,
other
nous les
members of
invitons
Parliament
à
or
se
members of the
signaler s'ils
Senate,
posent une question, à
please
signaler leur
let
fonction,
us know who you
afin de
are
pouvoir leur donner
when
évidemment
asking
la
your
parole le
question,
plus
because we would be delighted
facilement
to
possible.
give you the
Chacun de nos
floor.
3 intervenants
Now we have
interviendra pour 15 minutes,
3 panelists,
donc
and
un total
each
de
of
45
them will
minutes,
be speaking for
qui sera
15
donc
minutes,
suivi
1-5,
d'une série de
which means
questions-réponses,
45 minutes of presentations, and
45
then a
à 55
Q&A
minutes à peu près.
session
Nous espérons
that is
évidemment que les
scheduled
questions et les
for a
réponses
length of
seront
45
nombreuses,
to
signe de
50
l'intérêt
minutes.
que vous
We
portez
hope that there will be many
à
questions to
ce
answer,
colloque en ligne. Je vais
and
laisser
that
la
would be
parole à Dominique
actually a
Potier,
sign
puis
of your commitment. I will now give the floor to Mr. Potier,
nous visionnerons un film de l'ONG Mwatana for
and
Human
then we
Rights,
will
et
screen
au fur et à
a
mesure que les
film that
panélistes
has been
prendront la parole, je les introduirai
produced by
auprès de vous.
Mwatana Human Rights,
Mais
and then I
je
will
laisse
introduce
pour
our
commencer la
panelists
parole
before
à
they
Dominique
speak. But
Potier,
first of all, I will give the
qui
floor to
est
Mr.
présent parmi nous
Potier.
et
He
qui nous
is
fait
now
l'honneur de
with
présider
us,
ce
and
colloque.
it is an honor to welcome you,
Oui,
Mr.
chers
Potier.
amis, c'est moi qui tiens vraiment à vous
Dear
remercier pour la
friends,
confiance que vous m'accordez.
thank you very much
C'est
for
un
your
grand honneur,
trust.
c'est un honneur
First of
surtout
all,
qui
it
va
really is an
à toute
honor
la coalition qui a permis l'adoption en
to see
2017
that
de la
there's
loi
this
sur le
whole
devoir de vigilance. Cette
coalition
loi
behind me
vise à
that has
normaliser, à
also
donner
led
une
to
éthique au
the
commerce
bill
et à notre
on the
économie.
mandatory
Et
due
elle fait le
diligence to
pari
be
que cette
passed.
éthique et
Now,
la
this
condition même de notre
law
survie est une chance pour
says
notre nation, pour la
that
France, pour
that
l'Europe
it
et
is
pour le monde. Je
actually
voudrais
a
donc
chance
saluer
for
les
our
ONG comme
future, and
Amnesty
that we need
International qui
to
accompagnent
follow
une
our moral
coalition qui a
compass.
réuni des
So thank you very much
syndicats,
for this
des
coalition of
universitaires
NGOs,
et des forces
of
politiques dans la
academics, and of
diversité
other
a permis
political forces
cette
that
innovation qui
have
aujourd'hui est
allowed
en train
us
de
to
prospérer en
be
Europe, puisque
innovative
vous le
and
savez,
to move
le
forward.
commissaire à
Now,
la
we
justice a
have
déposé une
actually been
proposition
a
de loi à
leading
la Commission
example
qui
because
vise à l'adoption
there are
d'une
now
directive
other
européenne
bills
inspirée du devoir de vigilance. Donc
that
l'instrument
are in the
juridique
making,
qui justifie ma
including
présence
a new
aujourd'hui est une
directive
initiative
that
française qui est
will be
aujourd'hui en
put
train de
forward
rayonner dans le
soon
monde
by the
et
European
peut-être de
Commission. So we
s'enraciner
really
en
hope
Europe.
that
Je veux
this
dire
will
ça
be an
en
example and
préambule
that
parce que
will
ce dialogue, somme toute, que
become
vous organisez
a new
aujourd'hui entre
normality in
Amnesty
Europe.
International,
I wanted to
ECCHR
give you the context
et
because
le
this
Parlement
conference that has been
et tous les
co-organized by the
citoyens
National Assembly,
épris de paix et de
ECCHR,
respect des droits
and
humains est
Amnesty
exemplaire d'un
International
exercice
is
démocratique. Je
something something that is exemplary and a guarantee of the transparency in our democracies. Now, this is a thorny subject and bridge the gap between what is actually done when it comes to arms sales, what is done by the diplomacy and the preservation of human rights in the world is something that is not easy to overcome. We need to be brave here. We are witnesses of some of the most serious violations that have occurred in a long time, and without the NGOs, without the militants, not much could be done. Luckily, there is now more and more public debate. There are also debates at the National Assembly and also in other countries. So I would like to salute here the courage of those standing up, raising their voice, and make it impossible to forget what is going on in war-torn countries such as Yemen. In Yemen, there are some serious human rights violations, even war crimes. And this cannot be the seriousness of the crimes committed cannot be neglected. There are civilian victims, and the situation there is dramatic. We need, at some point, to raise our voice and say, stop. Yemen has been a war-torn country for several years, and it has to stop. Now, we need to think about the legal instruments that we can implement, in particular when it comes to French arms sales. And we also need to be aware of geopolitical balance, of diplomacy. We cannot afford to be naive. We know what consequences arms sales can have on the development of terrorism. And so this is not a Manichaean struggle between good and evil. No, this is something where we need to find a balance and show great awareness of what is at stake. When it comes to arms sales, the ideal can never be reached. We need to improve it, to make it better. We cannot just get rid of it. And I think that the way forward is to enforce control of what happens when arms are sold and transferred to other countries. I think this is going to be something that we're going to discuss today, how we can have arms sales that are not endangering human the values that have been defended by France for so long. So we cannot be naive, but we want to actually work for the peace and to be militants of human rights. Our position cannot be simplistic, but a lot needs to be done. So to me, this conference is not something that I would just chair and that I want to be seen as a manifesto or something that is radical. I want it to be an outcry, to actually be something that will lead the way forward for the next steps, for what needs to be done. We need to be humble. We need to also feel the weight of our responsibilities, and we need urgently to find answers to the situation in Yemen. Also, we need to draw lessons for the long term and to make change happen in the way arms are sold. International solidarity is something that we want to be, is a bill that we want to see passed during this legislature. I don't know whether this will happen. What I want is that France and Europe look for greater consistency between economic development, safety concern, and public aids. So to me, this reflection on the Bill on International Solidarity is something that can lead the way. I'm very happy that my colleague, fellow MP and friend Jacques Maire is going to join us. He is the rapporteur of an fact-finding mission whose conclusions will be published in a couple of weeks, and he will join us later, and I hope that he will be able to say also a few words. I'm sure that his investigation has been very thorough. I know his convictions, and so what we want is to seek the truth, and we want to enforce peace and human rights in Yemen and elsewhere. Thanks again for having me, and congratulations for this initiative. Thank you very much, Mr. Potier. Thank you very much for the work you have done in the past, for your support. Thank you for your encouragements and for supporting this conference. If you allow me, before giving the floor to Ali Jamil, who is a field researcher at Mwatana Human Rights, allow me to screen a short film on the tragic situation in Yemen.
أنا اسمي محمد أحمد الشرفي، عمري 30 سنة، أتكلم 3 لغات، أشتغل ترجم في السوق، يعني مرشد سياحي. فحياتي كلها في صنعاء قديمة، لأني عايش في متحف حي. المباني عمرها تقريبا 800 سنة أو أكثر، أما المدينة فهي من قبل الميلاد. طبعا خارج صنعاء قديمة أضيء، وين خرج من باب اليمن زي السمكة عشان تخرج من الماء تموت. شوف أمشي في السوق أنا وأطفالي، الولد يقول بابا، أقول له خلاص ارجع على البيت. ليش؟ خايفين، مشاكل. اسمع، حالات طوارئ، حالات من ايش؟ مش عارفين. نضوي بنشوف الاخبار ننذهل، ما بالله نجلس في البيت. تخيل موقف بيت من طين وحاجة، يعني الطين هذا أطرف شيء يهتدم. هذا كلام اهتزت صنعاء قديمة، خذيناه كلنا.
احنا ما كناش متوقعين انهم يضربوا المدينه التاريخيه او صنعاء القديمه، او بالنسبه لنا هذا اعظم معلم تاريخي للجمهوريه اليمنيه.
بالنسبه للضربه كانت بالنسبه لنا فاجعه. كان يومها يمكن الساعه 2 في الليل، كنا احنا ولله الحمد خارج، كتب لنا الله عمر جديد. اما بيت عبد القادر الذي جنبنا هم 5 أشخاص ماتوا الذي كانوا في البيت.
يدمر مدينة صنعاء التاريخية، ولا زال الأطفال ولا زال النساء تحت الأنقاض، والصاروخ لم ينفجر. يعني لو انفجر كان في أكثر من 100 أو 200 منزل. لا يوجد معسكرات ولا مدرعات ولا طيران. واليوم صنعاء هذه تناشد اليونسكو والأمم المتحدة والنائمين في العالم أجمع، يناشد ضمائركم الإنسانية، هل ترضون أن تدمر هذه المدينة وتشاهد الجرافات الآن؟ هي رسالة لكل أحرار العالم، ندين هذا العمل الإجرامي، الاعتداء السافر. لا يوجد معسكرات.
موقف مرعب. تخيل بيوت منها هدمه، ونسوان يبكين وأطفال يبكوا، وكل واحد يقول خير خير. تخيل كأن البيوت، كأن صنعاء قديمة خربت هذيك الساعة. صرت أنا في نفسي خفت.
الآن الجهل حقنا بيرقدوا العشي في خوف، بيقوموا في خوف، يصيروا المدارس في خوف. الرعب جاء فينا حتى الكبر وكل ما شكر الأطفال. الرعب.
بالنسبة لي أنا وعيالي أيتام. بالنسبة لبيت عبد القادر تيتموا 5 أسر. وبالنسبة للآثار الاقتصادية هذا ما احنا فيه، لا راتب، لا دولة دعمتني أنا بالذات حين عمرت البيت، كل من جيبي الخاص ومديون إلى الآن ولله الحمد.
والله اشتاق إن السياحة ترجع لي. كان دخلي أيام السياحة كان أشتغل أيام كان أخطأ مع الجروب طبعا 50 أجنبي، هذا يجي $5 من كل واحد 5 $2 $3 طبعا تجمع $100 $70 50 40 30 حتى $10. كان أيام زمان 2008 كان تنفع. من هذاك الأيام لليوم اختلفت 95% الميزانية. صح إن الحرب أثرت دمار شامل. وشو ما بالله أنا من 100,000 أسرة عاني.
ما هو الجريمة اللي ارتكبناها مع السعودي لو ما سايبنا قبل الإمارات؟ ما هو الجريمة اللي ارتكبناها معهم؟ ما بيننا وبينهم، إننا شحنا وياهم. لو ما يسووا لنا هذا الكارثة هذا كاملة يدخلونا في حرب لا لنا دعوة فيها ولا لنا شيء فيها.
تراثك يصير منك، تاريخك بشكل عام آلاف السنين تصير بتشوفها وما تقدر تفعل شيء.
So we've just seen a short video talking about what happened in Yemen and one of the events, and I will now leave the floor to Ali Jamil, but just before that I would like to make a technical announcement. If you just came in the conference, you can of course listen to interpretation. You have to click on the globe icon at the bottom bar of your screen and you can choose between English and French. And of course you can also put your questions in the Q&A box if you wish to ask panelists questions, and you'll find the icon between participants and the chat icon. Just before giving the floor to Ali Jamil, I would also like to tell you about a little change in program. The Member of Parliament, Jack Mayer, has given us the honor to be with us, and he will have the floor right after Ali Jamil, and then we will have Kanel Lavitte and then Patrick Wilken. Ali Jamil, you now have the floor. Just before, I would like to tell that you're a researcher at Mwatana Organization for Human Rights. It's an independent human rights organization that carries out field research, write reports and other documents about violations perpetrated by warring parties in Yemen. You also provide legal assistance to the victims of human rights violation and carry out advocacy actions on the national and international level for better compliance with the international law, so that countries and companies are held accountable for violations and to redress past violations. You'll have 15 minutes to talk to us, Ali.
Thank you very much for giving me the floor, and thank you very much for organizing this event. Thanks for everyone who is watching us on the live streaming. I'll excuse you for stopping my video because of some internet issues. You have just seen a video of one story that happened in Yemen, and I would like to tell you about another story that just happened 2 months ago. 2 months ago, Yemenis were celebrating the Eid, which is a religious event in which every house celebrate and people visit each other and families visit each other. During that day, there was families in a very remote area in Al-Jawf, which is a governorate to the north of Yemen. Families from this village wanted to visit their relatives in other village next to them. While they were on the cars, an airstrikes happened on the cars that they were in. 3 cars full of children and women. 23 of victims resulted in that incident. 8 of them were died, and mainly women and children. Our field researcher went to that place and made interviews and stayed there for a week. We couldn't reach him because it's a very remote area, no internet access, no network there. And when he came out, we were reviewing the evidence that we have on that case. And unfortunately, we couldn't find weapon remnants in that case. And it was because of many obstacles that we face in finding the weapon remnant. First obstacle is, in many cases, we go to the scene and we found out that all the weapon remnants that is in the scene are too small or too few to determine what's the type of the weapon that was used. And also we face problems with the de facto authorities because they go to these scenes and they collect all these weapon remnants. So in that case, we don't know where does this bomb come from. And we have documented 530 cases of airstrikes. We also don't know the majority of them, where did the weapon come from. We only know about 27 incidents. So on more than 500 incidents, there is a very big possibility that these weapons come from different countries in the world. So I just want to make here an emphasis that all countries that still transfer weapons or military assistance to the coalition might be complicit in these war crimes that happens on daily basis in Yemen. I know that many of you might stopped hearing about the war in Yemen lately, and this is not because the war in Yemen came to end. Unfortunately, the war in Yemen is still ongoing. And here is a couple of numbers for you. During the period of September 2019 and August 2020, Mwatana documented 28 airstrikes impacting civilians and civilian objects and resulting 190 civilians killed and 47 injured. We also have documented 78 ground attacks that killed nearly 85 civilians and injured around 198. We also have documented and on the same period around 37 incidents of landmines. So the war in Yemen is still ongoing. War haven't came yet to an end. And at the same time, maybe you don't hear about the war in Yemen because of COVID-19 and because of the American elections, but war in Yemen is still continuing. People are still suffering. And what adds insult to injury is that countries are still supplying military goods and weapons to the coalition and other warring parties in Yemen. We really call upon the French government that they reassess to do reassessment of their military transitions to Saudi Arabia and other coalition countries, and to stop these transfers of weapons to Saudi Arabia. And we believe this is the minimum that they can do. We really think that they can do much more than that, because France can have within its relations and within its relation with Gulf countries and also with the Yemeni country, with the Yemeni state, they can push for peace in Yemen. They can push for immediate ceasefire, and they can push for better humanitarian situation in Yemen, like opening Sana'a airport. Thank you very much, and thank you for joining this event.
Merci Ali pour ton témoignage. Je crois que
Thank you very much, Ali,
saluer
for
l'engagement
what you just said.
extraordinaire de votre organisation
I think
place au Yémen,
we can only
qui est
salute
subissé
your
dans les
bravery.
foudres de la guerre.
You are in the middle of a conflict, and it is very difficult to be a field researcher in those circumstances. I'm now going to give the floor to Jacques Maire. He is a member of the Foreign Affairs Committee at the National Assembly. He can be with us until 10 to 3. It is an honor to welcome you, Mr. Maire. So I will give you the floor shortly. Allow me just to say that together with Michel, Mrs. Tabarot, you are at the head of the fact-finding mission on the arms control that's been launched in November 2018. And in a few weeks' time, you will publish the conclusions of this fact-finding mission. The idea being that the Parliament will be given greater control over arms exports. Thank you very much, Mr. Eluin. My apologies for not being able to stay with you. The reason is that I have to be in a meeting with Mr. Le Drian, and it is related to the subject, so it's for the good cause. So first of all, I wanted to thank Amnesty and all the organizers of this conference. I think it is really very important to organize public events on this topic. It is important to have a full awareness of what's going on in the field and to realize what the political consequences are of decisions made here in Europe. So thank you for your work. I wanted to thank you personally, but to thank a number of NGOs who have been extremely helpful when we launched this fact-finding mission. As you said, we have started in November 2018. And to give you the full picture, this fact-finding mission wouldn't have happened without the war in Yemen. But Yemen is not part of this fact-finding mission, because if we had chosen to go that way, it might have had a lesser impact on a legislative change in France, and so we put a focus on what will allow us to have greater transparency and greater control in arms sales. What Mr. Jamil has said plainly shows that nowadays field researchers and NGOs are well equipped to collect evidence of the infringement of international law. They collect testimonies and they also look for evidence. That is something that wasn't being done 20 or 30 years ago. So this is a trend that we can only welcome. And what this will lead to is that the consensus regarding arms sales in France and in Europe will feel threatened. No, the consensus is trying to dissolve. A number of voices consider that security interests and that strategic partnerships have to include arms sales. This was the consensus before, and what we are seeing now is that it is more and more questioned. Now, our fact-finding mission had has two main aspects. The legal framework that we have nowadays is something we didn't have 10 or 12 years ago. And the states that are signatory to the European position in 2008 or the signatories to the Arms Treaty have not fully measured what it actually implies. And the question has been clearly brought forward by Dominique Pétier. The question is that of liability. So the liability, the civil and criminal liability, the administrative liability is not something that carries a great weight in case law, not yet, but things are changing, and of course a number of players may feel threatened. Now, the corporate world should be particularly concerned because the question of the criminal liability because of arms exports is being raised. Now, I find that the corporate awareness is actually not there yet, and they are not aware of the risks they are exposing themselves to. Now, with states, things are changing, but again, a lot needs to be done. Now, the State Council is also pushing that way, and we are sure that due to market integration, pressure will increase. Also, because of case law that will accumulate in trials where the corporate world will have to face their actions. Now, there's also a systematic underplaying of the risks linked to technologies. Now, technologies play a key role when it comes to arms sales, but we think that telecommunications and other aspects that are not linked to lethal weapons should also be considered. Now, the ministers have very little awareness of what the regulation is in that area. No. You need to go through screening to a targeted approach, and our authorities are not aware of the impact it has on civil populations in countries like Egypt, which is not a country at war, and even more so in countries at war. So we need to introduce visibility, we need more transparency in the control of arms exports. And then there is yet another aspect, it is the European dimension. France claims to be a champion of the integration of the market of arms sales. I think that the first priority is to be able to choose your client, and there's a paradox here. We face a paradox because France on the one hand claims to be in a leadership position, but when it comes to actual arms export, we do not show the right balance between the government and parliament. And so when you see this from the outside as a partner of France, you may wonder. So there is this claim to leadership, and on the other hand, a failure to live up to the expectations. These are things that are being debated in Danish and German parliaments, for example. So my conclusion here is but you know how tricky, how thorny a subject it is. So I am trying to put forward conclusions. We have been working for 2 years. We have been traveling a lot, discussing the issues with a number of partners. This is having we have audited more than 100 people. We have had a number of interviews at very high level, and we realized that we cannot make progress if we try to move things on our own. This is not at state level. This goes way beyond the level of an individual state. So what we need to consider is that if we want to live up to the expectations of civil society, we need a change of paradigm, we need a different approach, and we need to include new players such as Parliament. I'll stop there. I think that the first step is the kind of approach we need. And so I'm launching here a call for realism, and thank you again for your support.
Merci,
thank you.
Monsieur le député, pour cette prise de parole.
Thank you, Mr. Mayor, for your presentation. Yes, you have mentioned it. There are high expectations when it comes to this fact-finding mission. Yes, it's a step-by-step approach, the aim being that Parliament has more leeway to exert control. We have high hopes, and we'll see on the 21st of October. Am I right? If I'm correct, you and your fellow rapporteur will be audited on the 21st of October. This is scheduled for the 21st of October, but we'll see. There has been no confirmation yet. Well, you will follow keenly the outcome of this presentation, and thank you very much for being with us. So, let's now return to our program. Now, for those of you who just joined us, you have simultaneous interpretation into French or into English. In order to follow the conference with interpreting, you need to select the icon with the globe, and then between the icon chat and the icon participants, you will also find the Q&A icon. I'm now going to give the floor to Canel Levy. She is a lawyer specialized in business and human rights at the European Centre for Constitutional and Human Rights. The ECCHR is our co-organizing partner. They have been working now for a long time on arms trade, and the ECCHR has been working for the past 3 years on the role of companies and high-level government officials in the conflict in Yemen. Now, the ECCHR has already sued a number of companies based in Europe for being accomplices in crimes committed under repressive regimes or in areas of conflict, such as the Lafarge case. Canel, you have the floor.
Merci beaucoup, Emeric. Je remercie déjà bien sûr
Thank you very much, Emeric.
notre co-organisateur. Et puis surtout,
I'd like to
Monsieur le
thank
député,
Amnesty International, our co-organizer, and I would like to thank Mr. Potier. Thank you very much for being our kind host. We are virtually at the National Assembly, and I find that very symbolically significant. And like I said, we work on the role and the responsibility of economic players and their liability. This liability is something that happens when they finance armed groups and also in other situations such as arms exports. Now, the situation regarding the situation in Yemen, the role of European governments and of the industry is something that we started looking at with Mwatana. Now, we also partnered with Amnesty International and discussed what should be done in this particular context. We are an NGO based in Europe, and we are specialized in strategic litigation. Now, the way we work, the way we are being militant is by having trials. This is what decided us to make a communication at the ICC. We asked the OTP to open a pre-investigation about the facts that I'm going to tell you about in a couple of minutes. So why did we decide to go for the strategy of a communication with the ICC? Now, if you remember the video you've seen, if you remember what Ali just told us, this is a cast conflict. The war has started in March 2015, but the attacks on the civilian populations and on infrastructures allowing them to live is something that has been ongoing and starting even before 2015. Now, there are the NGOs, the local NGOs who are doing incredible work, but also the UN who is documenting the conflict and providing evidence. Now, we think that there is a violation of international criminal law and international humanitarian law and of human rights. And there's a link between the arms industry based in Europe and which is complicit of the coalition led by the United Arab Emirates and Saudi Arabia. Now, in terms of strategic litigation, this is also a very high-profile case. Why? Because we regularly face two obstacles. Now, the first one is that the arms exports industry and their corporate structure is highly complex. It is multi-layered. There are a number of legal entities. Now, the production chain is highly diversified, and in our communication to the ICC that was submitted in December 2019, if you look, for example, at the military aircraft fleet of Saudi Arabia, you find 4 European companies in the UK, in Italy, in Spain, and in France. Now, components, for example, are produced in one country, then the assembly line is in another country, and it is a third country that is in charge of export, which means that liabilities are being watered down. Now, where we want to act is prevention. And so we need also to put the companies in a position where they can identify the risks to human rights when they export to a country that is represented by the United Nations as an actor of serious violations and possible war crimes. Now, the second obstacle that we face regularly, and where the situation in Yemen is exemplary, is the claim of legitimacy. It's a presumption of legitimacy on legal grounds, on moral grounds that are claimed by certain European companies. When you talk to the arms industry, when you ask them what their obligations are, what about the exports to Saudi Arabia, they tend actually to say that since they were awarded license by the government authorities, they don't need to look further. And that for us is, of course, something that is difficult to handle, because it means that a given individual has to comply with due diligence, but it also comes short of the global responsibility of companies involved in arms exports. And so allow me now to describe the facts in the communication that has been submitted to the ICC. So the communication was made by ECCHR, by Mwatana, and together we organized a coalition with Amnesty International and other European NGOs. Now, we tried to address two questions. The first one is the arms exports to Saudi Arabia and the United Arab Emirates. Are these exports in contradiction with the international treaties, and what are the responsibilities and the liabilities of the arms exporter when they know that the conflict is likely to produce violations, serious violations of international criminal law and humanitarian law. Now, in our communication to the ICC, we focus on airstrikes. Why? Because airstrikes are carried out by all the warring parties, but mostly by Saudi Arabia and the United Arab Emirates. And they are also the main cause of civilian casualties and of buildings that are either listed or that should not be targeted. We have identified 26 airstrikes thanks to the research work done in the field by Mwatana, and we were able to show that these 26 airstrikes could be characterized as serious violations of international human rights or war crimes. Now, there have been civilian casualties, civilians have been killed, but it is also a crime because schools, hospitals, cemeteries, or residential buildings have been targeted. So that means not only civil casualties, but it also means that an entire community is no longer able to have their most basic social and cultural economic rights, such as the right to go to school. Now, we have, for example, evidenced those attacks by collecting fragments of bombs, for example, an MK-80 bomb that you remember the video that was telling you about that particular airstrike. Now, when you find a fragment, the fragment that was found is evidencing the reliability of an Italian company, RWM, an Italian company. No. Then with the evidence is also based on the air fighter fleet of Saudi Arabia. Now, Saudi Arabia has 124 such military aircraft, and 59 of those aircraft is produced by Dassault, the French company. And then there are also the pods, the designation pods that are produced by French companies such as Thales or others. So all the accessory material that allows the strikes is produced by companies that are based in a variety of European countries, in France, amongst each other. That Delàs is in particular target of our communication. Now, based on these facts, we ask the following question: when someone is exporting arms that have been facilitating the commission of war crimes, are they an accomplice? Are they aiding and abetting? So in order to establish that, we based ourselves on the very origins of criminal international law and on case law by going back to the Nuremberg trials. Now, at the time, several high-level German industrials were tried at the Nuremberg trials after the Second World War. We based ourselves also on more recent case law in Europe, in particular in France, and this is the Lafarge case, but also in the Netherlands. Executives, company officers have been condemned for arms exports, for example, in the civil war in Liberia in the 1990s. Now, based on this analysis, we considered that one could talk about aiding and abetting, about complicity. Why? Because there is a substantial aiding and abetting through the export of arms. And there's also the intention element. the intention is established because they want to export the weapons and they also know that they're aiding and abetting the commission of serious crimes. Now, there is one particular point that I'd like to dwell upon related to the responsibility of governments and of corporate executives. And I'd like here to ask three questions. Do the arms export companies have licenses independently? Now, do they know, do they have to know what the exports are going to be used for? The second question is, can they reasonably ignore what the consequences are? And thirdly, do they know what the legal consequences are? No. We have here an expert, Patrick Wilkin, who is an expert on mandatory due diligence. But yes, to the first question, the answer is clearly yes. Companies have the obligation to identify risks, and they need to identify risks along the whole supply chain. So when we're talking about the arms manufacturer, the risk that needs to be identified is, of course, the fact to identify where it is going to be used.
En Europe ont la connaissance que nous avons toutes, donc des informations publiques, mais elles ont également une connaissance de terrain qui est très importante. Quand on livre, quand on exporte une arme, ce sont des
companies who export also know what the situation is in the field. They're usually technologically advanced. There is training in the country that is going to be using those weapons. There's the supply of ammunition. And so because of all this complex logistic chain, the suppliers cannot ignore what the situation is in the countries to which they're selling. Thales, for example, a French company, has employees in Saudi Arabia, so there's a structure, a corporate structure that is implemented outside Europe, and those companies have the expertise and have the knowledge of what is going on, so they're perfectly capable of establishing the risk of abuse. No, it is now a long-drawn conflict, as we know. The war started in 2015. So what happens to a company when they haven't identified the risk and when they're not facing their responsibilities? So what are the consequences? Now, the first kind of answer, if you look at the case law in Holland, in France, or a case law of international criminal law, yes, they have criminal liability. If you export arms, then you should also face the consequences. And then there's also civil law, and this has to do with liabilities more upstream. This is something that Patrick is going to talk about. And if I remember correctly, Dominique Potier said that the purpose of the discussion, the debate today, is to try and help clarify what the responsibilities are of companies and how we can help companies to help them to better identify the risks that are linked to their exports.
Merci Canel. Merci Canel pour
Thank you very much, Canel.
Nous allons céder maintenant
and I am now
à Patrick
giving the floor to Patrick Wilkin.
Thanks very much, Aymeric, and thanks to colleagues in Amnesty France, ECCHR, for organising this fantastic event, and to Dominique Potier for chairing the event and supporting this initiative, and Jacques Maire for his interesting contribution. I do agree with him that there needs to be a kind of paradigm change in France and other European and other countries that are sort of major exporters of weapons for far greater transparency and scrutiny over these very important decisions. I mean, it's often said that the decision to go to war is one of the gravest decisions a state can take. And by extension, the decision to assist others in going to war through arms transfers is an incredibly important and serious decision, and a decision with huge consequences, as we've seen in Yemen and from that quite moving film that we were shown. And whether states or indeed companies like it or not, even if they're not directly party to a conflict, they are linked both morally and importantly legally to the conduct of that that conflict through the transfer of arms and other equipment, and often in the most tangible way possible, as Ali was talking about, and indeed Amnesty has done similar research, retrieving fragments of weapons from strike sites which could be considered as war crimes. So you have really a company logo that's associated with the killing of civilians in many instances across Yemen, and there have been many instances documented, even despite the huge challenges, as Ali pointed out, of documenting and retrieving those fragments from often remote areas and strike sites that have been, thoroughly destroyed. So I think that there is obviously huge public interest in this issue. We see in poll after poll across Europe and in other countries a great anxiety about the arms trade, particularly certain type, elements of the arms trade, and outright rejection of, by large majorities of trade with countries like Saudi Arabia, of weapons for use in Yemen. So it's actually paramount that there's this sort of maximum amount of scrutiny, as Jacques Maire pointed out, from Parliament. And not just from Parliament, from civil society, from organisations like Amnesty International, many others, from UN bodies, and also where necessary from the courts. And this is where, I would wanted to look at this whole issue of transparency and lack thereof, which is a real problem in France, and it's a problem in many other countries that export weapons. And it's a problem that really has to be overcome before we can have a system that is fair and legal, and that does not end up, resulting in very serious human rights violations in countries like Yemen. So, obviously France is a major player in this area, and by some estimates is, the largest exporter of arms, behind the US and Russia, with about 8% of export market by CIPRI estimates. And it does seem to specialize in the very high risk end of the export market. So Egypt and Saudi Arabia are major clients, and there are major defense agreements that stretch back years. But despite this fact, despite the fact that France is a big player with a big presence in high-risk markets, there is very limited scrutiny over how the decisions are made, and if there are safeguards, if there are discussions about the human rights impact of those decisions. So looking at, for instance, the actual decision-making process in France, we don't really know much about it. We know the theory, but not the practice. So the theory is there's an interministerial group that meets regularly, discusses the various licenses, and advises the Prime Minister, who is the decision maker, the sort of sole decision maker. But what we don't know is what actually goes on behind closed doors. So we don't have any information about what those discussions have been, if they've discussed human rights impact, if we have no information about the safeguards they may have put into place in particularly controversial cases like supplies to Saudi Arabia. So we have a very behind the closed doors political decision. And then when we look at the involvement of Parliament in France, there's an annual report that is presented to Parliament and discussed, an after the fact report, after the decisions have already been made. And we see in this annual report, again, a lack of substance, a lack of concrete information about what discussions have been made on specific decisions. There's very limited information on, there's no information, in fact, on who the end users or the end use agreements that have been made for specific transfers. The data that's presented on the actual transfers is, it reveals certain elements of the transfers, but it's impossible really to pin down from that data the precise equipment, the parts and components and the ammunition that's being delivered into these conflicts. For instance, there's one table on deliveries that just gives a brute financial figure, which isn't broken down in any way to different equipment that's been transferred. And so, and then, if you go beyond equipment on the military list and look at equipment that's being supplied to police forces, the situation is even worse. It's impossible really to track police equipment, which we've seen across the world has been used and misused for very serious human rights violations. So there's really not the raw material for Parliament or other bodies or civil society to work with to question how these decisions have been made. And that is a really fundamental problem. Just looking at the corporate side, and here again, we have very large companies with huge resources, but that are giving out almost no information really in terms of their involvement in this trade. In spite of the fact that France, has been a pioneer in mandating human rights due diligence for the corporate sector through the Loi de Vigilance. And I think the defense sector, as Kanel mentioned, has been very slow to cotton on to the fact that there is a regime now. Has been a lot of discussion about the business and human rights framework through the UN guiding principles, OECD guidance and so forth, of what the responsibilities businesses have across their whole value chain in terms of conducting human rights due diligence. And here France is kind of ahead of the pack by taking that framework, that very well established framework, and putting it into law. But despite that fact that there is a legal obligation on the companies in France, we see that the actual plans, the due diligence plans that companies such as Thales, Airbus, Dassault have presented in response to the law, are extremely, do not reveal anything, in fact, about the riskiest element of their business. They talk about internal dynamics of the labor rights within the company. They talk about supply chain issues, but don't actually mention the one area of their business which is extremely high risk, i.e. transferring weapons into conflict zones and into countries experiencing political upheaval. And instead they just have kind of very abstract assurances and vague statements of intent. And so the real battle now in France, I think, is that the France has led the way with mandatory due diligence, but it has to now be meaningfully implemented. And I think companies like states, they need to ask and answer some extremely basic questions in order to meet standards of due diligence and also legal obligations for the state under the various arms control legal frameworks. And those questions would be really looking at specific cases, looking at concrete cases like Saudi Arabia and the situation in Yemen, and asking, very basic questions about, what are the dynamics, what are the human rights risks in the country, what is the destination country's, track record in terms of compliance with international human rights and humanitarian law, how have weapons, specific weapon types been used in the past, and have they been connected to potential human rights risks? There's also the question of accountability. Are there accountability mechanisms so that if there are problems in the destination country, those problems can be addressed by that country? Those assessments should be public, they should be dynamic, they should be ongoing. There's been enormous changes, for instance, with the Yemen conflict that completely changed the calculation in terms of transfers to the Gulf, and should really have been, there should have been reconsideration of the licensing process in the light of all these changes. At the end of the day, both the state and the company, if they really can't show that transfers of weapons are safe and secure and don't risk their being linked to very serious violations of human rights and international humanitarian law, then they shouldn't be exporting. And we obviously believe very strongly that states should not be licensing equipment, and that companies should not be transferring equipment even if they can gain a license. I mean, I think that's the point of the business and human rights framework, is that companies have freestanding responsibilities, and they cannot be absolved of those responsibilities through a state licensing system. So I'll leave it there. I mean, I think, just to conclude, I think that the lack of transparency has undermined trust in France and other countries. And what you have instead of transparency is leaks, revelations, media exposés, quite embarrassing research sometimes from NGOs and UN panels on the ground that gradually, drip by drip, exposes this complicity between France and other countries in very serious violations and deaths of civilians in different countries. And so it's really in France's interest to really open up this discussion and to start talking honestly about the trade, its impact, and its human rights implications. Thanks very much.
Merci Patrick pour ton intervention, extrêmement claire. Nous le voyons, nous avons maintenant terminé les interventions des trois participants, des trois panélistes. Ali Jamel, chercheur à Mwatana for Human Rights, Canel Lavitte, juriste donc contentieux entreprise chez ECCHR, et Patrick Wilken, donc chercheur sur le contrôle des armes et la sécurité à Amnesty International. Nous allons procéder maintenant aux questions, prendre les questions qui nous sont adressées. Donc allez-y, vous pouvez nous les adresser, nous les transmettrons aux différents panélistes. N'oubliez pas que vous avez accès à la traduction simultanée.
You have simultaneous interpreting. So you have the globe icon at the bottom.
Première question,
So,
donc question de Max. quelles sont les difficultés
First question.
auxquelles sont
What
confrontées quelles sont les difficultés qui vous confrontent pour traduire plusieurs entreprises en justice dans plusieurs pays qui attribuent à la
difficulties that
production et à
you
l'armement d'une
face
arme
when taking companies to court that are operating in different countries? Now, Kenel, would you like to answer that? That's an excellent question. Thank you very much. I think that what you could say first is that the prosecutors' offices in France or in other European countries are not well equipped enough to investigate, especially when it comes to a transnational transborder investigation. And this is also was part of the choice of taking a number of entities to court with the ICC, because they have this transnational jurisdiction. Now, then there is another difficulty.
Le fait que ces armes et que la production de ces armes soit fragmentée, je dirais, entre plusieurs entités juridiques, si l'on veut appliquer le droit pénal, ça nous rend les choses extrêmement difficiles parce que
if you want to apply international criminal law, it is also very difficult to identify where a decision has been made, which individual was in charge of proceeding with an expert when there is a risk of complicity.
De présenter, je pense que si l'on regarde par exemple la loi sur le devoir de vigilance français, c'est là
to echo something that Patrick has just said, when you look at the Loi de Vigilance, the mandatory due diligence, it is very helpful in order to go past that difficulty of identifying a given individual, because the whole company has to apply due diligence all along the value chain. Now, the idea here is, if even however good the due diligence law is, if you applied it to Thales nowadays, of course, you wouldn't have all the answers we need. However, you could, for example, extend the mandatory due diligence to a company that would be working together with Thales in Italy. And so when they receive a component that has been produced by Thales, they could then decide not to export it to Saudi Arabia. This is a case where a component is being manufactured in France, and that chain should be analyzed when it comes to risk. So a company that is based abroad and that is exporting should be part of that due diligence. Thank you very much, Canel. Patrick, would you like to add something?
Non, si... Oui.
Patrick?
Yeah, I mean, I think there is this question, obviously, of a patchwork of jurisdictions and the difficulties of the trade being so internationalized and parts and components going between different countries. And in fact, the complex systems now, a fighter jet, for instance, will have the participation of sometimes scores of states and companies that are incorporated in different ways in different jurisdictions. I mean, I think what is, in terms of the whole due diligence question, what is important is that, you have the Loi de Vigilance in France, but it's looking like that is, France is leading the pack, and there will be many similar laws that will spread across Europe. And we, as has been mentioned, there's also the European Commission's preparation for a potential directive that could mandate human rights due diligence across the EU. And so I think, what we're seeing, what I would say companies should be thinking about is that they're at least in Europe, there's likely to be sort of pan-European regulation in this area, there should be fewer loopholes, at least in Europe, in years to come.
Merci Patrick pour ton intervention et ton complément de réponse. Une personne nous contacte pour savoir s'il est possible d'avoir accès à la communication soumise à la CPI.
We have one question, one person would like to know, one participant would like to know whether the communication with the ICC is accessible, is publicly accessible. So please correct me if I'm wrong, but I think that it is actually not publicly available. But Canel, do you want to maybe add to that? No, exactly. For safety reasons, we cannot actually make the entire communication public, in particular when it comes to the safety of the witnesses that have been interviewed by Mwatana. Now, what about the jurisdiction of the ICC? How can the responsibility of the companies and the governments be established when it is actually obvious that none of the states that Yemen is not a signatory to the Statute of Rome? Canel, and then Patrick later on.
Oui, pardon, Patrick. Non, peut-être voilà rapidement, effectivement,
yes.
La compétence de la CPI.
No, the question about the jurisdiction or the competence of the ICC. No, it can be based on the fact that the state where the crimes have been committed is signatory to the Statute of Rome, but also if the situation or if the Council of Human Rights of the United Nations is asking the ICC to investigate. Now, Article 12.1 also stipulates that if an individual is linked to the commission of a crime, so war crimes in Yemen, if the crime has taken place under the jurisdiction of a state that is a signatory to the Statute of Rome, then you can actually proceed with the investigation. And here we have several European states who are signatories to the Statute of Rome, which means that there is a jurisdiction of the ICC.
Merci, Canel. Patrick, veux-tu
Thank you very much, Canel. Patrick, would you like to answer that question?
No, just to kind of add that I think, you know, the concept of kind of extraterritorial responsibility is embedded in international human rights law and in the whole arms trade framework, so that, you know, states do have responsibilities that for events that happen in third countries. But I think it's clear that in this communication, which I think what I would say about the communication, which was, I think, really interesting and innovative, is that it took on the two elements that are connected with the arms trade, not just the state licenses, but decision makers in companies and it's important that both of those elements are put together because they both have, you know, key roles in the business. And I think they have responsibilities that are extraterritorial because their business, their products and services are being used on a daily basis across Yemen.
Merci Patrick pour ces compléments. Donc une question
Thank you, Patrick, for these clarifications. Another question about the duty to vigilance and what are the so Patrick, this is for you. I'm sorry, I'm going to repeat the question. What tools are on display for the state for more transparency? So repeating the question, so we talked about the duty of vigilance for companies, but what are the tools at the national level in France for more transparency? So Patrick, if you want to take the question, or Canel maybe?
Yeah, I mean, I think there are many tools, but that are not being used, as I pointed out, that there's clearly a lot of information that the state holds on these arms transfers. They're obviously intimately involved in all elements of the process, but they're not releasing that information, and simple publication of risk assessments, decision making, and the actual transfers, the end users, the end use of that equipment would go a long way into clarifying what is actually happening in terms of France's involvement in the arms trade, particularly in those very sensitive regions and countries that France exports to. So, I mean, I think that it's a question of political will, really, and efforts to be more open and to open up to scrutiny. Which, I mean, you could say that it's a lot of states like France are not doing that because they in some ways fear that scrutiny, because a lot of the transfers are clearly contradict obligations under international, regional, and domestic law, and are very, very difficult to justify. But I think if there was true transparency and scrutiny and independent oversight, that would be hugely positive for all stakeholders in this process.
Fait. Merci encore pour cette réponse.
Thank you so much for your answer. There is another question for Canel, maybe.
En coopération, il y a, semble-t-il, toujours un chef de file.
In arms program, joint arms program, there are always someone who leads, and isn't he the one who has the main responsibility and that vigilance duty you're talking about? I think that we have to distinguish between legal responsibility and moral responsibility for a person within a company, depending on the function, the role they play. The duty of vigilance means that it's not the person who gives the instruction and who assesses the risk that bears the responsibility, but you have to identify who bears the responsibility. And this is why we consider the company as a whole as a legal entity. However, while implementing the law on due vigilance, and that's what the NGOs are calling for, like Amnesty, these NGOs have worked a lot, like Sherpa as well, they've worked a lot on guiding these companies. When a company identifies a risk, it needs to propose measures to mitigate this risk and explain which means will be implemented to mitigate the risks. So, and what knowledge will be needed, maybe training, so that within a company, measures can be taken to assess the risks and to prevent rights violations that are linked to arms exports. So if we talk about responsibility in the vigilance law, it's really a pragmatical question. We need to find a way to implement this law. Thank you, Canel. So, Patrick, would you like to add something? If not, then I have another question. Patrick?
That's fine.
Très bien. Sinon, j'ai une question de Stefano Trevisan,
from Stefano Trevisan, who works
l'ONG Lighthouse Reports.
At the NGO Lighthouse Reports. He's a legal consultant.
the question, donc, according to business and human rights due diligence standards, the arms manufacturer must carry out a risk assessment that is strictly related on the human rights impact related. Ah, excuse me. Excusez-moi. Excusez-moi, j'avais éteint mon micro.
Alors, a mic issue?
J'ai une question donc de
So,
Lighthouse
again,
Reports.
We have a question from Lighthouse Report.
According to business and human rights due diligence standards, the arms manufacturer must carry out a risk assessment that is strictly related on the human rights impact related with the specific weapon it intends to export. Is the company obliged to take into account the marginal human rights records of the importer? In other words, what is the threshold of the risk assessment? General on the human rights record, or rather more specific on the specific weapon to be exported? Patrick or Canel, Patrick?
Yeah, I mean, I think that's a kind of an interesting question, which I think you know, really in terms of human rights assessment, you're looking at the potential for human rights harm. So it's harm, it's not due diligence in the sense of harm to the company itself, but harm to others that may be impacted by their business. So I guess that's the prism that you have to look through. And in terms of arms manufacturers and exporters, that would mean, as I mentioned, assessing all those elements of an arms transfer. So of course it would be weapon type. You see that in France has a big aerospace kind of industry. It supplies parts and components and whole fighter jets. So exports of that sort of equipment into the current Yemen conflict are obviously enormously risky because of this track record of errant airstrikes. Many of them are probable war crimes, and aircraft repeatedly hitting medical facilities, residential areas, funerals, factories, and so forth. So yes, the weapon type would be fundamental. So too would be the end user, the track record of Saudi Arabia, what Saudi Arabia's kind of attitude is towards international human rights law, the accountability mechanisms that they have, the last 5 years of the Yemen war, and what their conduct has been in the Yemen war. And so, I mean, if you took all that into consideration, I would imagine that it would be impossible to construct a case where you could say that that export did not have extremely high risks of harming individuals as a part of the business. So I mean, I think anything that relates to human rights harm should be taken into consideration in a risk assessment.
Canel, est-ce que tu veux compléter?
Thank you. Canel, do you want to add something in that regards?
Bien.
No, thank you.
Alors, il est
Great. So,
les présentations
during the panel we had, we understood something. The companies claim that they act, that they export thanks to the licenses that they have been given via their states. However, the reason, the ground on this right to export depends on the executive power in France. So it depends on the state. However, companies also work to influence the government to write legislation, to write new regulations, or to implement them. Companies have an influence on government. So the question is as following.
With the or more broadly to the responsibilities and legal obligations of companies. Canel, maybe. Peut-être.
Je peux commencer.
Yes, I will start. I think that there is a breach between the interest of the companies and the government. Is it relevant to the responsibilities of companies? I don't really have a clear answer. However, the first conclusion I can draw is that when we talk about knowledge at the company level and about their duties to act and to maybe pause their exports, then we can include within this knowledge the expertise they have about legislation put forward by the government. If we think that the companies are going to have a role to play when the legislation is being drafted, with all the legislative tools, then we cannot think that when they're granted the export license, they suddenly wash their hands of it and say they don't have anything to do with it, then it makes no sense. Of course, they know that Article 6 of the Arms Trade Treaty says that we should not export arms if there is a risk that their use might violate the international right. And the Article 7 of the same treaty includes more details. So if the company knows the legislations, then they have this obligation to know and show that they know the international right.
Nous avons une question.
Thank you very much, Canel.
Patrick, je t'en prie.
Please, you have the floor.
Yeah, no, I just wanted to add that, obviously that's it's an excellent question and a fundamental problem with the whole arms trade is there's a huge degree of influence on the companies, or a kind of interpenetration between the companies and state entities. There's state ownership of parts of the company. There's a lot of personnel that intermingle and state aid and promotion of the arms industry, diplomatic promotion of the trade. What I would say about the company's responsibility, I mean, the companies again should not be undermining any protections that the state attempts to make on human rights grounds, and that's where the example that comes to mind where companies have been arguing for much looser regulations with higher human rights risks was again related to Saudi Arabia when Germany announced a suspension of future licenses because of concerns over human rights. You had many leading, in fact, CEOs of some of the big corporate defense companies coming out against that measure and criticizing it and saying that Germany is undermining the European defense industry, and that criticizing a move that was designed to protect human rights. And I think that that's another kind of form of irresponsibility that the corporates have in this regard. They should never seek to undermine regulation that is trying to safeguard human rights.
Merci Patrick pour cette réponse, pour ce complément.
Very much,
Nous avons
Patrick.
maintenant une question pour
And
Ali.
we now have a question for Ali.
Ali, Qu'est-ce que
Now, Ali,
vous pensez de
what
cette action devant la Cour pénale
do you think of
internationale
the communication with the
quels sont
ICC?
vos espoirs vis-à-vis
So
de
what
cette
are your
action?
hopes regarding what has been undertaken in the communication to the ICC?
Thank you very much for the question. We think that the communication that we have submitted is one of the very rare avenues of accountability that we have available for Yemen. Our hopes are really high. We hope that something comes out of this, and we hope that the ICC investigate on the communication that we filed and look also on other crimes that happens in Yemen. But we'll see what come out in the coming period.
Merci Ali. Une autre question d'ailleurs.
Thank you very much, Ali. And I have another question for you as well.
Quelles sont les activités autres au-delà
So what else beyond the communication to the ICC, what else can be done? What is Mwatana doing in order to hold accountable those who export arms, who transfer arms? So what else can be done by Mwatana in order to stop the transfer of arms to countries which are responsible for the situation in Yemen?
Mwatana is having an accountability team who are all focusing on bringing all perpetrators accountable on the crimes they have been complicit in. We have done some work on universal jurisdiction. We have done some work on the ICC, as previously was mentioned. We're also doing some advocacy on that regard and working on establishing international mechanisms that works on investigations in Yemen. Yesterday, there was a renewal for the mandate of the GEE. The new mandate will give them more responsibilities and more chances for bringing for investigations in these war crimes. The last report of GEE stated clearly that it's a necessity that accountability should happen in Yemen and perpetrators should be held accountable. The GEE also mentioned in the last report that was published last month that countries who are been transferring weapons to Yemen and mentioned some of the names of these countries can be complicit in international crimes that happens in Yemen and can be responsible of aiding and abetting in international crimes.
Merci Ali pour cette réponse.
Thank you, Ali, for your answer.
Nous allons continuer sur la logique du contrôle de ces exportations d'armes.
So let's pursue on this topic of arms control and control on export. One question regarding the treaty. Now, the treaty mentions the obligation of assessment when there is a serious risk of violation of humanitarian rights, but the participant who is asking the question is also mentioning that Article 6 and 7 of the treaty are not demanding enough. The expectations of risk assessment are not very high.
ATT is useful in the context of states allowing arms exports to the Saudi-led coalitions. Or should we move towards a more demanding standard, putting the burden on states to assess the risk and continue to do so in a manner similar to the principle of non-refoulement, where states are accountable if there was a real risk, so even before the harm actually materializes. Patrick, peut-être?
Yeah, I mean, I think, you know, obviously, I think the Arms Trade Treaty was a great achievement. It's a great achievement for civil society after a long campaign, which Amnesty was at the forefront, and it does set down very key principles which connects arms transfers to human rights violations in Article 6 and 7 being at the very core of the treaty that had got, you know, into these very, you know, key principles. In terms of the implementation, yes, I think we've seen progressively through various Conference of States parties a difficulty in actually enforcing treaty obligations. There's a lot of, there's a huge amount of literature about how states should be interpreting Articles 6 and 7 and what sort of questions that states should be asking in order to do a robust and rigorous risk assessment as per Article 7. But there is where the treaty lacks teeth is kind of enforcing that, and also the question of transparency rears its head up again in terms of you know, how do we really know what states are doing to comply with Article 7, and that's where again, we perhaps going around in circles here, but without the information, it's very difficult to assess. And here in the UK, there's been, you know, the very interesting judicial review, which has given us a glimpse, forced by the courts, into that decision-making process from a UK perspective, and shown it to be, you know, deeply flawed. But, you know, that was forced by a court process, and even in that court process, the government produced some of its evidence in closed court. So we didn't really get the full picture there. But, you know, it's true that the Arms Trade Treaty has set a paradigm, but like many treaty bodies, the implementation is lacking. And I think what we really, at this point, what we need to do is to strengthen what we have and continue to work and campaign. You know, there are many other stakeholders, including civil society, that can try and press states to be more transparent, and also challenge states, if necessary, through the courts to apply the Arms Trade Treaty. But I would, my position on that would be that we, after a decade spent trying to achieve some kind of common standards, and actually succeeding in getting a treaty that has been, you know, ratified by, you know, a very large number of states, we need to work with that system and to try and improve it.
Merci Patrick pour cette
Thank you,
réponse.
Patrick, for your answer.
Une autre question pour
Another question for Ali,
qui rejoint peut-être un peu ce qui a déjà
that
été
might
posé,
build on what we've already said, but it's still an interesting
Ali,
question.
peux-tu préciser
Ali, can
les
you
objectifs
clarify, sorry, what the objectives with the ICC communication are? So what's the goal?
à atteindre?
What do you want to reach with this communication?
On this communication, we want to hold accountable those who have been in authority in transferring and licensing of weapons that were carried out to Yemen and then used in war crimes in Yemen.
Bien.
Thank you.
Merci,
Thank you very much, Ali.
I mean, I could.
Je t'en prie, vas-y.
Sorry,
Patrick,
I
go
could
ahead.
just could add something on that. I mean, I think this ICC communication, as I said, it was driven by ECCHR, but we were part of the coalition. From our perspective, I think, you know, I totally agree with Ali that ultimately it's to hold account people who, you know, both states and corporations that are complicit in war crimes in Yemen. But, you know, it's also, I think, to explore all these various issues about legal complicity of both states and corporations, and to foreground the issue. I mean, we're hoping, obviously, that prosecutors take up the issue. There's been a lot of interest, but I think even at this stage, it serves a role to highlight the situation in Yemen, the links between that situation and corporate actors, and the links to licenses. And it's part of a process which, again, you know, ECCHR has played an enormous role in, that Canel was talking about, and other NGOs such as CAT in the Campaign Against the Arms Trade in the UK. Part of this process of really trying to use strategic litigation to try and force states to live up to their obligations that they freely entered into. I mean, it's not as if any state was forced to ratify the Arms Trade Treaty. They freely entered into that obligation. And now it's a question, as with a lot of other treaty law, it's a question of really using any means we have as civil society, whether that be exposing violations that Ali talked about, whether that be, you know, looking at strike sites and trying to get remnants that link countries and companies to human rights violations, or whether that be court processes, and those court processes could be in national courts or you know, in the ICC. I think it's all grist to the mill of efforts to make states more accountable and get states to live up to their national and international obligations.
Merci, Patrick.
Thank you, Patrick. Let's move on. There are many questions. There's a question. Why can't we prosecute the states themselves? Because they are either using the arms or they are granting the license to export them. So, Canel, do you want to answer that? Yes, gladly. That's a good question. I think we partly answered this question, but within the communication to the ICC, we talk about states' responsibility. It would be possible to prosecute states. It all depends on national legislation. Can you, in your own country, have a court that prosecutes a state and its responsibility? In some countries it is possible, but that's definitely a path that can be considered. It's actually a path that is being used in the UK already, not so much in criminal responsibility, but in administrative responsibility. ONGs have asked for some export licenses to be withdrawn because, according to these NGOs, the licenses were violating the Arms Trade Treaty. And this is one way of holding the states accountable, to put the state, to face the state with its responsibilities and its commitment. Thank you for the clarification, Canel. And we have another question. Companies that create bombs in France, can they be prosecuted in France? Yes, actually, in France, we're one of the rare countries in Europe that have a criminal responsibility or competency for moral persons. So, and there are some precedents. For Lafarge, for example, as we've talked about, it's one of the cases where a company was prosecuted as a moral person. And I think this question can be linked to the previous question about the ICC. It's one of the aims we have with the communication. We want to show within the legal debate that economic actors that have a neutral activity can be implicated in violations and can be prosecuted by the criminal law. So we want to show that the behavior of these actors can be prosecuted. And when I talk about the jurisdiction in the Netherlands or for the ICC, you have to understand that the corporate leaders have very sketchy relationships to foreign government leaders who have committed war crimes. So there is already a legitimacy issue to chair these companies, be it for Lafarge in France or for other companies. This is a different company. These companies executive officer have a neutral activity, and we need to have a change in behavior, in mindset, in the way we implement the law. And this is what we're doing with some academic work, with this conference as well, to say that yes, it is possible to tackle this issue. It is possible also to tackle the companies, the economic actors, because they do play a role in the conflict, in the continuing of the conflict. And I think that we are at the crossroads here, and we really hope that the countries that are currently under conflict will be able to rebuild themselves. Thank you, Canel. Thank you so much for what you said. We are being told that the Commission, the European Commission, works on observing the supply chain, and there is a draft legislation on the supply chain, but not on the whole value chain, including experts. So, of course, this is a big issue. Because the approach is not complete. So, after this comment, another question. Can the license, the export license, actually exempting companies from criminal liability? I think we might have already answered that, but Canel and Patrick, do you want to make this even clearer? I can start, and Patrick will complete my answer. Yes, we've already answered this question a bit, but that's definitely the core of the problem. No, the license don't exempt the company from their responsibility, and definitely not from their duty. They have to assess the risk, they have to prevent them. And when a license is being granted, this license is valid for several years. It can be an individual or a collective license, which means that once the company receives a license, they will be able to export for several years. And the context might be different from when they've been authorized to export after all these years. So I think that as soon as a license only assesses the risk at one point in time, there's a problem. There should be a continuing risk assessment. And in the UNGP, there is an encouragement to always assess the risk as time goes by. And this definitely applies to arms trade. Thank you, Canel.
Yeah, I mean,
Patrick, go ahead.
Yeah, thanks. I think this is a real key question, and we did do some research and contacted many large arms companies specifically on this question. And their response was that essentially arms transfers is a political decision. It's taken by the government, and they are merely kind of suppliers to that government to fulfill government contracts. And I think that this is an incredibly flawed answer. And it's an answer that hasn't taken into consideration the great strides and consolidation of the whole field of business and human rights. And I think that while some sectors have received more scrutiny, such extractives, the tech sector, garment industry, and have maybe accepted, maybe perhaps not fulfilled or implemented their obligations, but they have accepted that they do have these human rights responsibilities. The arms industry has kind of hidden behind this licensing process. But at the end of the day, they are private companies, or even if they are part or fully state-owned, they are covered by the guiding principles and the various other guidance and frameworks and French law. And they have boards, shareholders, they have CEOs, they have the full kind of setup of a corporate entity. They are making decisions. They're making decisions with certain knowledge, and they're not forced to trade and export to Saudi Arabia. Even if they can achieve a license, it's not like they are being compelled by the state to export into Egypt, for instance. It's a decision that they have to make. It's a risk assessment that they have to make, and one which, as we've seen, may have illegal implications. So that these companies obviously have legal departments, legal counsel, that has to consider their exposure to these risks. So I think from my perspective, the situation is clear. And certainly in Europe, the industry and the sector, I think, really has to catch up with current thinking on these issues.
Merci Patrick. Eh bien, nous approchons de la fin.
We are now nearing the end of our conference. Maybe one final question. And then I will hand over to Mr. Potier for the concluding remarks of this online conference. So, question. Do the governments provide the companies help with the assessment of risk? Canel, Patrick?
Well, I mean, I think at the moment there's a lot of overlap, as I mentioned, between government and industry in this area, and at the moment there are separate processes: the government process, the license process, and the company's own internal risk assessment processes. But if the company was carrying out its human rights due diligence properly, then it would obviously seek information from all stakeholders, including the government, which is probably the most vital one, and the Department of Defense, Ministry of Defense, and all other actors that were participating in the process. So yes, there should be companies should be actively seeking out information from the government to ensure that their business is secure and human rights compliant.
Merci Patrick. Canel,
Thank you, Patrick. Canel, would you like to add something on this topic?
Nous approchons de la fin.
Okay, it is now nearly 4. Mr. Potier member of the National Assembly, would you, so before handing over to Mr. Potier, Ali, would you maybe give us some final remarks regarding Yemen?
Thank you very much. Yemen really needs peace and accountability. We really encourage all countries to push for that. Thank you.
Merci Ali.
Thank you very much, Ali. And now, without further ado, I will hand over to Mr. Potier for the concluding remarks of this online conference. Thank you very much. Mr. Potier is no longer audible. This conference was really very useful in order to highlight the issue in all its complexity. Mr. Potier is again not audible. Mr. Potier is still on and off and cannot be heard. Can you hear me now? I am outside Paris. I live on a hill. So my role is obviously not to give you some final truth, but just to maybe try and point the way forward. Now you have provided us with analysis, and I think that two things need to be done. Since the beginning of this initiative, there's one thing that's really urgent, that's the situation in Yemen, and then there is the longer term. And that is more related to the trade of arms, to geopolitical issues, etc., and the rules that need to be defined and enforced. Now, if we want to be able to move forward, we need to draw the lessons from Yemen. Now, what is happening in Yemen is something that is happening in a different shape elsewhere, and that will happen again somewhere else in the world. So it is very important, crucial to help Yemen to find a way out of this terrible conflict, but we also need to draw the lessons in order to apply what has been learned elsewhere. So there is the short-term emergency, and then there is also the need on the medium term to move forward and to do things that will be beneficial for humankind everywhere. Now, listening to you, I was reminded of two things. Now, first of all, there are things that you cannot do when you are part to a conflict. You cannot attack civilians. That is embedded in international treaties. You cannot ignore it, and especially if you are a signatory of a treaty, a United Nations treaty. Now, where civilians' rights are violated, then what you have is a catastrophe for civil society. So it is unacceptable to have civilians as frontline victims of armed conflict, and that must be repeated again and again. And then the second thing is that arms trade is such an economic mammoth that it endangers the political decision-making process. And you have underlined the mingling of government authorities and arms manufacturers. This is the case in France. This is the case also in a number of regions in the world. And so we need a neutral party, a third party, something that guarantees that public authorities cannot be corrupted by vested interests. And public authority needs to be able to discern what the right way is, what the right compromise is and make sure that it finds the balance between the security interests and the compliance with human rights. And NGOs here play a key role, whistleblowers, but also parliamentarians have a role to play. Parliamentarians should be in a position where they can say what is good and what is true. And you have put forward two possibilities, and I think they're both very interesting. No, something that has to do with the enforcement of the Statute of Rome and informing the ICC here seems to be an excellent strategy. The informing is asking for pre-investigation in order to establish liabilities along the chain. Now, ECCHR, through its communication with the ICC, did something that was strategic, and I think that you chose the right instrument in order to put some light on something that is very obscure and hidden from public view. Now, the second thing is to involve parliaments more. Because, yes, there are reports, but there's also a lack of transparency. And I think we need to fight for a reform where Parliament has a greater say. Now, the fact-finding mission whose rapporteurs are Michel Tabarot and Jacques Maire, and whose conclusions will be made public in the coming weeks, will launch a debate. We will make sure that the questions that have been asked in the report are debated at the National Assembly, and that we stop looking the other way. I want for Parliament to be able to influence the decision-making process in the medium term and in the long term. So I would welcome a greater role of Parliament, and I think that the fact-finding mission here is really a unique opportunity to act as lawmakers. And then maybe something else. An interparliamentary dialogue, and I noticed the question asked by our German colleague. So I think that beyond the dialogue between national parliaments, in this case the French Parliament and the German Parliament, a debate that would bring together all national parliaments in Europe would be something very welcome in order to raise the awareness of the need to comply with the defense of human rights. I think that arms trade is really something that needs to be debated also at the European Parliament, and that this could lead to taking stock of what is really going on in Europe. Now, a parliamentary debate between French and Germany could be a launching pad, but I think that really a lot of lobbying needs to be done at parliamentary level in order to put an end to a situation where only the arms manufacturers and the governments are making decisions. Finally, have reminded us how the compliance with due diligence all along the value chain and the supply chain is something that we need to aim at. Now, this has also to do with human rights and the protection of the environment. It has to do also with liability, the liability of corporate entities when it comes to their RSAs. Now, what about the choice of a customer? No, I think that the due diligence, the mandatory due diligence is completely compatible with our search for shared responsibility. I have no doubt there. However, how can we legally enforce this? The legal instruments that we can avail ourselves in French law, are they actually enough in order to condemn the use of a given type of product, even beyond the question of the use that is made of that product? I am not sure that this is really an avenue we need to explore. If the debate goes that way, then we will need to adapt, think about it, and maybe new instruments will be designed. Now, two dates to keep in mind. The first date is that of an assessment mission of the due diligence law. We have asked 3 years after the bill was passed into law to assess the impact of the law and how companies have been compliant. Now, this fact-finding mission, in which I will take part, will, after this conference, will be able to take advantage of everything that has been shared here. And I can assure you that this will enable us to better define the scope of our assessment mission and to see whether the due diligence law is up to game. You know that with 4 other countries, Denmark and 2 others, there has been a report of the Ministry of Justice. There has also been lobbying of the NGOs. There has also been lobbying by the bishops of the Catholic Church, unions, etc. So a very large coalition alliance who push for due diligence to become, of course, something that long-term could become a UN treaty, but first of all, something that would be EU directive. Now, once we have the project in front of us, we will be able to act in defense of human rights. So here are the dates and the next steps. I wanted to tell Ali, Canel, Patrick, all the organizers, how much this conference meant to me. Now, the fact that you give voice to the plight of our brothers and sisters in Yemen is something that means really a lot to me. We cannot give up on trying to do something so that their plight ends, and we also need to have instruments that in the long term can reinforce the control process of our democracies. We need to show the way forward for the whole of humankind. The alternative is darkness, barbarism, and we will know that humankind will suffer. So thank you very, very much to all of you. And I'm sure that a number of other parliamentarians here in France and elsewhere support your work. Thank you very much and congratulations.
Merci Dominique, pardon. Merci Dominique, je passais en mode...
Thank you very much, Mr. Potier.
Je sortais du mode muet. Merci pour votre intervention et nous prenons acte des engagements, de la force
Thank you for all those next steps that you have told us about, and thank you for your motivation. I think that we are going to bring this conference to a close. My sincerest apologies for all the questions that we haven't been able to address or to answer, and I am sure that we will carry on the work we have started together with members of parliament, with government authorities and with the NGOs in order to improve the situation. We want to combat human suffering by having a better regulation of arms trade. Thank you very much, Mr. Potier, for chairing this conference. See you all very soon.